Hi everyone, welcome to SQE1 window, and here we start our journey into property practice. So in chapter 1, we try to talk about like conveyancing process comprehensively. So we'll just talk about fundamentals of conveyancing and that how it works. So it sounds like a bit tricky and dry topic, but we will try to signpost everything around convincing process that how it really works in real life. So to start with, let's start with the basics. What exactly is convincing, like how it works, what does it mean? So at its core, convincing is the legal process by which ownership of land or property transfers from a seller to a buyer. But here is what makes it unique in England and Wales. It operates as a highly structured sequence of stages, and each stage has very special legal consequences and professional responsibilities attached to it. Now, here is the crucial point that you absolutely must remember for your exam. Until exchange of contract occurs, this entire process is completely non-binding. So that means either party, buyer or seller, can walk away at any time without any legal comeback. They can just say, I have changed my mind. That's it. And the process is gone. So, but and this is massive, but once exchange happens, everything changes. Like the contracts are exchanged between the parties become legally committed to the transaction. If someone tries to pull out after exchange, we are talking uh, there will be serious financial consequences. So keep in mind every time it is asked in exam, what is the status of parties, legal status before exchange of contract, non-binding, and after exchange of contract there is legal commitment, and parties they need to honor it. So there are 5 stages of convincing. Just to give you a map of this journey, the convincing process consists of 5 distinct stages, and we need to know these like the back of our hand at that point. So stage 1 is the pre-contract stage. This is all about preparation, title investigation, searches and inquiries. Think of it as the due diligence phase, what property is. So all about property, legal and other aspects of buying property. Stage 2 is exchange of contracts, where things become binding, legally binding. And remember what we just said, this is where it all becomes real. And before that, it is all like you can say what ought to be. It is not like what law says it should be. So stage 3 is pre-completion formalities. Between exchange and completion, there is still work to do. Final searches, preparing deeds, getting funds ready, and stage 4 is completion. This is the big day, the transfer of legal ownership and the movement of funds. Keys get handed over and the buyer becomes the legal owner. Stage 5 is post-completion administration, paying stamp duty, land tax, and registering everything at land registry. So these are all 5 stages. So so examiners really want to test why. They want to know if you can identify what must be done at each stage. Who is responsible for doing it, whether it's the buyer's solicitor or seller's solicitor, and the legal consequences if there are errors or omissions or delay. So as we go through each stage, pay close attention to those 3 elements: what, who, and consequences. What will be done, who will do it, and if it is not done in the proper way, what will be the consequences. So stage 1. All right, let's learn about stage 1 in detail, the pre-contractual stage. This is where all preparatory and investigative work happens. So from the seller solicitor perspective, here is what's happening. They take instruction from their client, they investigate and deduce title from the land registry, essentially providing the seller actually owns what they are trying to sell at that point. They prepared the draft contract incorporating those standard conditions of sale. You shall need to know about these conditions. So they complete property information form and the fitting and content form, and then they send this entire package over to buyer's solicitor. So meanwhile, the buyer's solicitor is equally busy. They are taking instruction from their buyer, carrying out local authority searches and other property searches to check for any surprises. Things like planning issues, environmental concerns, and local authority restrictions. They raise inquiries about the contract and the property information. They investigate and report on the title to make sure it is all legitimate. They ensure the mortgage offer is actually in place, and they report everything to their client and get authority to exchange. Now, here is the critical point about this stage. At any moment during this pre-contractual phase, either party can withdraw without any consequences. And this explains some practices you might have heard about, like, where the seller suddenly accepts a higher offer from someone else, or at that point where the buyer drops their offer at that point and they change their mind. So this is quite fuzzy phase, like at that point, and quite like fragile phase, like for both buyers and sellers, and of course for solicitors as well. So stage 2 is exchange of contract. Now we hit the critical legal moment, exchange of contract. This is where everything transforms from non-binding arrangement into a legally enforceable contract with serious consequences if you pull out. So let me emphasize this. Exchange is the pivotal moment in the entire conveyancing process. The solicitors formally exchange contracts, usually by telephone, using one of the Law Society formula. And yes, you should be familiar with this. Those formula will be, those are tested on your exam. So what happens at exchange? 4 massive things. First, a binding contract is created. We have gone from we might do this deal to we will do this deal at that point, and that's legally enforceable. Second, the completion date is fixed. Both parties now have contractual obligation to complete on specific date. Third, the buyer pays a deposit, typically 10% of the purchase price. This deposit is usually held as stakeholder, meaning the seller's solicitor holds it on behalf of both parties, or sometimes as agent for the seller. So, fourth, and this is crucial, withdrawal is now prohibited. If either party tries to back out after exchange, that's a breach of contract with serious financial consequences. And what consequences? Well, the innocent party can claim damages for their loss. They can forfeit or retain the deposit, and in some cases they can even seek specific performance. And we have talked in land law, every land is unique and specific performance works on it. And specific performance is a court order requiring the other party to actually complete the transaction. So you can see why exchange is such a significant moment in the property transaction or conveyancing. Let's talk about pre-completion, that's how it works. So this session is going to give you 360 view of everything in property, almost everything in property practice. So that's what we are trying to talk today. So stage 3 is pre-completion step. Between exchange and completion, we enter stage 3. The pre-completion stage, both solicitors have essential preparation work to do to ensure completion can happen smoothly on the agreed date. Accuracy here is absolutely vital because errors can delay or even invalidate completion. So let's break down what's happening at this stage. So the first thing is pre-completion searches. The buyer's solicitor runs final searches against the property and against the seller. Why? To make sure no adverse entries have popped up since those initial searches were done. Remember, some time has passed and things can change at that point. New notices can be entered on the register. So second stage or second step is deed preparation. The buyer solicitor prepares the transfer deed. That's the TR1 form. And if there is a mortgage involved, they also prepare the mortgage deed. Every party need to execute these correctly. So third, financial arrangement. The buyer solicitor requests fund from the buyer and from the lender. Calculates the exact completion monies down to the penny everything and prepares everything for same-day transfer. Fourth, requisition on title. The seller's solicitor answers any final queries, confirms the mortgage redemption figure, and makes sure all documentation is ready to go. This stage is all about getting your duck in a row, because when completion day arrives, everything need to happen like, in a very timely fashion at that point. So the next is completion stage, how completion works. We have tried to signpost you on this slide that how it works. So completion day arrives in stage 4. This is when legal ownership actually passes from seller to buyer. It's the transfer of entire, or you can say it is the day where entire conveyancing process becomes mature. So in the morning, there are final checks. Both solicitors are confirming that funds have been received, everything is in order, and they are coordinating with each other to make sure completion can happen. Then comes the fund transfer. The buyer solicitor transfers the balance of the purchase price, usually by CHAPS, which is same day electronic transfer. Speed is crucial here. Once the seller solicitor confirms receipt of those completion monies, they authorize the release of the key. The keys either go to the estate agent or directly to the buyer. And then this is the magic moment. Legal title passes. From this exact moment, the buyer has legal ownership. They have right to occupy the property immediately, the right to insure it, the right to deal with it however whatever they want to do within law. One important point, although completion usually happens on a specific agreed date, technically completion occurs the moment seller's solicitor confirms receipt of money. That's when ownership transfers. So if you get an exam question about when does the buyer become legal owner, it's when completion monies are received and confirmed, not when the keys are handed over. The keys are just symbolic. The money confirmation is what matters legally at that point. The first stage, post-completion. Finally, we reach this stage, post-completion. So you might think the buyers moved in, job done, but actually there is essential administrative work that still needs to happen to perfect the buyer's legal title and fully finalize the transaction. So let's look at all of it. The seller solicitor has to redeem any existing mortgages and on the property, obtain confirmation of redemption, either a DS1 form or electronic END form, at that point from the lender. And then account to their client for the net sale proceed, send the discharge of mortgage documentation to buyer solicitor, and then file everything away and close the matter. The buyer solicitor has even more critical task. Within 14 days of completion, this deadline is crucial. They must submit the stamp duty, land tax return, and pay SDLT to HMRC. They shall get an SDLT 5 certificate back. Then they need to apply to register the transfer at His Majesty's Land Registry, of course, and this must happen within priority period from their searches. They also register the buyer's mortgage as a legal charge, send the legal document to lender, and report completion to their client. So here is something really important for your exam. Legal title is only truly transferred or perfected once registration at land registry is completed. So legal title, keep in mind, legal title is done once it is registered with the land registry. Until that registration happens, the buyer only holds an equitable interest, not full legal title. And if you miss that priority period, you could lose priority to other registered interest. Like people can register interests on that land. That's a disaster scenario that could lead to professional negligence and, of course, claims. So, taking instruction, seller and buyer, how it works. So let's shift gears and talk about those initial considerations that happen right at the very beginning. When client first walks through your door, taking clear, comprehensive, and accurate instruction is absolutely critical. Get this wrong, and you are getting up problems that will haunt you throughout the entire transaction. The seller if you are working for the seller, you need to gather full names and addresses of all sellers. If it is a couple, you need both the property address and whether it's freehold or leasehold at that point. So details of any existing mortgages and the outstanding balance, information about any deposit they have paid on the related purchase, because many sellers are also buying. What fixtures and fitting are included, that's also you need to look at, and their expected completion timescale. So you need to know name, addresses, title of property, freehold or leasehold. You need to look at any mortgages, deposit, how it was paid. You need to look at fixture and fitting and fixtures, and of course if there is a chained property transaction that someone is selling and then they are buying on other side. Because it is a property, it involves money. Money laundering is a big compliance task that you need to do. So let's talk about money laundering compliance, because this is huge in conveyancing property transaction and that poses risk of money laundering. So at that point, solicitor must comply strictly with the Money Laundering, Terrorist Financing and Transfer of Fund Regulation 2017. Let me break down key requirement. Customers' due diligence. You must verify the identity of all clients using reliable, independent documentation. That means confirming both identity and current address through original document or certified copies. Electronic verification alone might not be enough for high-risk transactions. Second, you need to look at source of funds and you need to raise an inquiry. This goes beyond that confirmation about who someone is. You need to understand and document where the money is actually coming from. This is especially critical for cash-intensive sources or funds coming from overseas jurisdictions. Ongoing monitoring, not only you need to do it, you need to just keep an eye on it. Throughout the transaction, you are watching for suspicious circumstances, red flags, including unusual payment structures, client being reluctant to provide information, use of multiple bank accounts, or unexplained third party getting involved in that transactions. Reporting obligation, if only suspicion arises, you must make a suspicious activity report, SAR, to the National Crime Agency or the money laundering officer at your firm. And this is really important bit. Failure to report when required is a criminal offense, but also if you tell the client you have made a report, that's called tipping off. That's also a criminal offense. For your SQE1 testing, at that point in exam, they test it. They shall give you a fact veteran and ask you what you should do. What is your obligation towards money laundering at that case? So SRA Code of Conduct and Independence, let's talk about it. So there are certain principles we need to keep in mind. Of course, you have just studied all of it in your legal services and professional ethics, but we will just include it here. Principle 5 says acting with integrity. You must act with integrity in all professional dealings. No dishonesty, nothing that would undermine public trust in the profession. Principle 3, act independently. You must maintain independence. When developers or money laundering, they try to influence you at that point, you need not look at money. You need to look at your independent judgment. Client best interest, you act in client's best interest always. That means providing clear advice even when it's commercially inconvenient, and putting your client's welfare above your own interest, that you're getting 3,000 for that transaction, £3,000, and you ignore. No, you can't. Public confidence, you must uphold public trust and confidence in profession. Any arrangement that even gives the appearance of impropriety, so even if technically okay, risks breaching these principles. And these are common scenarios which are tested in SQE1. So the next is conflict of interest. It's very important. It's tested. Conflict of interest. This is of course, the solicitor must not act where there is conflict of interest or even a significant risk of conflict between clients or between the solicitor's own interest and the client's interest. So acting for buyer and seller, generally you cannot act for both, even if they are both established client of yours. The potential of conflict is too great. There are rare exceptions for sophisticated commercial entities with independent legal advice available for all of them, but those are truly exceptional. Acting for borrower and lender, this is actually permitted. You can act for both buyer and their mortgage lender because their interests are aligned. At that point you can. But at that point, once again, you need to keep and uphold integrity in that transaction. So the confidentiality rule, imagine you are holding confidential information that you should uh, disclose to one client, but you can't disclose it because of duty you owe to another client. What you do, like at that point, there is conflict. So at that point, confidentiality should prevail. You cannot disclose without consent, but equally, you cannot continue acting while withholding material information. The only solution is to cease acting for one or both clients, but most of the time for both clients. Last point appears constantly in exam question when confidential information cannot be shared. Your duty of confidentiality overrides other duties, and the correct response is to stop acting, not to breach confidentiality. So next is joint power and undue influence. Oh my goodness, it's very, very important. Let's discuss it. Joint powers and undue influence. This comes from the landmark House of Lords case, Royal Bank of Scotland versus Enbridge. The issue arises where a mortgage involves joint borrowers, particularly in domestic relationship, where one party might have undue influence over the other. Special safeguards apply to protect the vulnerable party, in husband-wife, or partners relationship. Step one, recognition of risk. You need to identify transaction where there is potential for undue influence. Typically, this is where one party gets, little or no benefit from the transaction, but is providing substantial security. Step two, separate representation. The vulnerable party must receive independent legal advice from a separate solicitor. You cannot advise both of them at that point. You need separate lawyer to advise them. Don't run after money. Let them take another solicitor. Step 3, private meeting. The independent solicitor must meet with the vulnerable party alone without the other borrower present. That can just wink and manipulate things. This ensures free and informed decisions. Step 4, full explanation. The solicitor must explain the nature of the document, the practical implication, and the risks involved in clear enough terms that the client can make an informed decision. Step 5, written confirmation. The solicitor then provides written confirmation to the lender that independent advice has been given. This protects the lender's security. What does this matter? Why this matters? Proper compliance protects the lender. Their security won't be set aside later at undue influence kind of pretext at that point. So, contract rates is amazing. That's also one of the things. We all are greedy. People want to make money, and they attract contract races, which are not allowed. And you as solicitor cannot involve in that. So contract races, this is when a seller issues a draft contract to multiple prospective buyers simultaneously, planning to exchange with whosoever or whoever ready first. Ethically, this is problematic and creates risk for everyone. As a solicitor, if you are involved in a contract race, you must inform your client that a race is occurring. Warn the seller's client about the risk, including reputational damage. Inform all competing buyers that there is a race, and consider whether continuing to act is consistent with your professional obligations. Most of the time, you need to inform that you cannot involve in contract race and cease to act. Failing to disclose a contract race to all parties may breach your duties of integrity and acting in the client's best interest at that point. Undertaking. An undertaking is a personal, professional promise by a solicitor. Amazing. That's what you need to understand. So, being solicitor, you can't say, and you say, I just said it, I'm a joking. No, you can't. So, an undertaking is a personal, professional promise by a solicitor to do or refrain from doing something. These are binding and must be performed precisely as given. Breach of an undertaking is serious professional misconduct. Key principles: only give undertaking where performance is within your control, that you got money in your control at that point. Do not give undertaking on behalf of third parties you cannot control. Perform undertaking exactly as worded and within any time limit, and recognize that breach may result in disciplinary action and personal liability. So common example include undertaking to redeem mortgage or discharge charges. The golden rule: never give an undertaking unless you are absolutely certain you can fulfill it. So the next thing, we got FSMA 2000, financial rules. We will just talk about it. Let's talk about Financial Services and Market Act 2000. As we talked about FSMA, this is important because it defines the boundaries of what solicitor can and cannot do regarding financial advice. I had a question from this one. So FSMA regulates financial services and products in the UK. Solicitors are generally excluded from needing FCA authorization, but only when they stay within specific exemptions. So here is what you can do. Generic information. You can provide generic information about mortgages, explain different types, explain the legal process, explain implication of mortgages and all of it. But you cannot give specific advice, recommending particular lender, comparing specific mortgage products, or advising on whether particular mortgage is suitable for a client or not. So at that point, you should not act like, financial advisors. So your proper role is legal advice only. Advise on legal implication of mortgage terms, identify risks and all, but not which one is financially viable. When a client needs an advice on mortgage suitability or product selection, referral is necessary. Send them to FCA authorized independent financial advisors, and that will save you. So here we are, bit tiny font, but we had to do it with tips and certain things that we need to keep in mind while we are attempting in our exam. So the first, start with timing. Always ask yourself first, has exchange of contract happened? If exchange, legal. If it is not, people can pull out. Know the transfer point. Legal ownership passes on completion, not exchange. Exchange creates a binding contract but does not transfer title. And of course, this is common error in tip 3. Searches and inquiries come before exchange. SDLT, payment and land registry, often comes after. Pre-completion searches become between exchange and completion. Get the timing wrong and you lose mark. Ethics override convenience. If disclosure of information conflict with confidentiality duties, do not disclose. Stop acting. Confidentiality prevails. Conflict matters. Buyer and seller. Acting for both is usually prohibited. Only you can act for lender at that point because interests are same. Undertaking is binding on you. Once you make it, you need to perform it. And FSMA boundaries, you cannot act as financial advisors. And on the top, that is on my mind and that is tested, the real ownership, legal ownership is transferred once the title is registered at His Majesty's Land Registry. So I wish you all the best, and if you like it, subscribe, share with your friends. Ta-ta for now.